Hello, good morning to all of you. Myself, Advocate Varun Kumar. So today we are organizing a podcast series on ADR Unpacked Mediation, Innovation, and the Kerala perspective. So today we have a very special guest with us, Advocate Joel Kenneth Johnson. So I welcome you to sir on this podcast series. If you can give a short intro about yourself to our readers, so later on I can start asking questions.
Thank you, Varun. Thank you so much for having me here. By way of introduction, my name is Joel Kenneth Johnson. I'm an advocate by profession. I practice in the High Courts of Kerala, Karnataka, Punjab, and Haryana, as well as the Supreme Court of India. I am an accredited arbitrator and a mediator, and I'm empaneled within the Supreme Court and the MCPC. I right now I'm co-leading the Knowledge and Communication vertical in the Mediation Society. I've done my undergraduate, that is BA from Symbiosis International University, my LLM from National University of Advanced Legal Studies, Kochi, and I have taken a diploma in IPR from National Law School, Bangalore. That is my way of introduction. And before I start, I just genuinely want to say that law audience, I approach law audience because it has built something quite rare. I feel like it has built a platform where legal ideas get discussed with real depth and where audience is genuinely curious rather than just looking for answers. So that is not something that you find everywhere, and it was exactly the kind of space where a conversation about area belongs.
So my first question to is alternative dispute resolution as a practice area.
Honestly, Varun, if I'm being candid with you, it started with kind of a discomfort. And I mean that quite literally because lawyers like us, we spend too much time spending in courts now. And we watch cases move through the system and we start realizing and noticing something quite doesn't add up. Because most clients are not really chasing a judgment. They are chasing a closure, so as to say. They want to feel that someone heard them, that their dignity was respected, and that they can move on. And that traditional system that the court gives, it often can't give the justice that the clients want in the pace or the shape they actually need. So this gap actually bothered me. So I started researching, I started looking sideways. And that's how I got into it. Yeah.
Great, sir. How would you explain mediation to someone unfamiliar with legal processes?
If I have to tell them in one word, I would say mediation is a space where you are heard before anything is decided about you. This is the simplest version I would give to anyone who will ask me in one sentence what mediation is. See, mediation does not judge. Nobody tells you who's right, who's wrong. Nothing is imposed on you. What you have is a structured conversation, and you have a third party, a neutral third person, who will help both this side to move past the position that they're very hardened to, and talk about things that actually matter to them. So that is mediation. That is how we'll explain to someone who does not have a legal background.
Okay. So my next question to you is how has ADR evolved in India over the past decade?
See, there are very considerable changes. Bigger shift, I would say, is that ADR moved from being optional to being almost inevitable, especially in several categories of the dispute. A decade ago, if you notice, mediation felt like something that we would try after litigation has exhausted everyone, a last ditch attempt. Right? This has definitely changed. In the today's scenario, it has definitely changed. Courts are now using Section 89 of the CPC to refer to mediation much earlier. And now the Mediation Act of 2023 is there, which is a real landmark. For the first time, I would say mediation has its own dedicated statutory framework in this country. And that changes the conversation completely. ADR, people does not see it as an alternative anymore. In many sectors, I would say it has become a parallel track that is built directly into how justice system operates.
Okay, sir. So the next question is what role does mediation play in reducing the burden on courts?
Mm, See, I have to say that it is less about the numbers game and more about a filtering mechanism. Mediation filters a lot of things. India has over 4 crore of pending cases now. That number is almost incomprehensible. But large portion of those cases don't actually need a full judicial determination. What they would need is a structured dialogue and a workable settlement that both the parties can live with. Say a family dispute, neighbor conflict, it could be a small business disagreement, or it could be even be civil matters where both the parties basically understand what a fair resolution looks like, but they are locked into their position. So mediation is designed precisely for those. When those cases move to mediation table and get resolved there, court can actually do what courts should do: adjudicate disputes that genuinely require authoritative reasoned decision. So I would say that is where the real breathing room comes from. It is not about reducing the numbers. It is more about routing the cases to the right forum.
Okay, sir. So, do you think India is developing a strong mediation culture? Why or why not?
Yes, yes, obviously. Because look at the MCPC and Supreme Court now. They are ready to train anyone who is ready to get trained for mediation. See, it is not fully organic yet. Mediation culture is not fully organic yet, but push is still coming from the judiciary, from the institution, from the law school. Like the organization that I work from, Mediation Society, we work deliberately to see that awareness of mediation at the ground level. Law alone, I don't believe it changes the mindset. Exposure does not. So where I work, Mediation Society, where I am collaborating with, we are registered as a not-for-profit organization in Kerala. We have received over 800 applications for a training program in 8 months, and we have trained over 200 people so far. So I believe that is not a small signal. It tells you that curiosity is real, that it is coming from people who haven't been fully absorbed into the adversarial culture of litigation. That's a seed, I would say. The more the people would experience mediation firsthand, whether as parties, it could be as negotiating lawyers, it could be as students, the more natural it will become to default to it rather than to file for litigation immediately.
Okay, so now coming to the Kerala perspective, how does Kerala stand out in terms of mediation, adoption, and awareness?
Kerala has built something that is very genuinely strong. The Kerala State Mediation and Conciliation Center, which operates under the High Court, they coordinate over a network of 70 mediation centers across the state, right down to the taluk level in most places. So this geographic spread matters enormously because mediation in Kerala it is not just available in Ernakulam or Thiruvananthapuram. It is accessible to people in district or taluk court as well. That's the infrastructure with real reach. And I would say what excites me more is young lawyers like me and student engagements that happen here. People are stepping into ADR early before their instincts have been fully shaped by the adversarial practice. Because once it is shaped, it is very difficult to go back from that. Because I'm seeing it daily. Young people are choosing to engage with mediation before litigation has become the default right. So Kerala has a huge future in mediation.
Okay, sir. Are there any unique institutional or cultural factors in Kerala that support mediation?
There genuinely are. Kerala has a long tradition of community level dialogue, whether it is in the family court, whether it is in the religious communities, it could be even the neighborhood setups where people sit together, we talk through dispute before they escalate into the formal conflict. We may not term it as mediation because we may not understand the concept of mediation back then, but that culture of conversation existed before a long time back. That doesn't mean that Kerala doesn't litigate. Of course it does. There's a baseline openness to sitting at the table first, particularly when it comes to family and community dispute. And when that cultural willingness is channeled through a proper structured process, with trained mediators who hold the space with skill and genuine neutrality, it aligns remarkably well with how mediation is designed to function. So I would say that infrastructure and culture are pointing in the same direction here. That is not something every state can say.
Okay, so can Kerala serve as a model for other states in promoting ADR?
Yes, in terms of awareness and court connects infrastructure and even grassroots engagement, yes, absolutely. A statewide network of mediation centers is there, structured training for judges, lawyers, and there's a monitoring framework that track what is actually working and what is not. But I would say we have to strengthen the quality and the consistency of training here in Kerala. We have to create clearer professional pathways for mediators themselves. So if we have to do that systematically, I would say Kerala can demonstrate something very important, that mediation doesn't have to stay confined to metropoles. It can reach taluk level and be effective there. That's a story I would say worth telling to other states.
Okay, sir. What are some emerging areas within ADR that young lawyers should explore?
So, when it comes to the emerging areas, I would say what excites me right now is the online dispute resolution, that is the ODR. See, that combines area process with digital platforms to make resolution faster. So even the policy backup is there, like EDIOG, ODR roadmap is actually pushing this direction. Now there is a Mediation Act of 2023, and that is one thing, ODR, online dispute resolution. Another I would say is a startup and technology driven dispute, because parties in technology driven disputes, technology driven world, they need speed and flexibility above almost everything else. No, so a courtroom timeline simply doesn't fit how they operate. And the third is the commercial mediation, like the supply chains, the MSME dispute, or the cross-border business relationship, where preserving the relationship matters as much as the money. So I would say these three are the emerging areas within the area, and the mediator who genuinely understand business can add enormous value in those spaces.
Okay, so the next question is, how is technology influencing mediation and dispute resolution?
I talked about ODR before, no, online dispute resolution. So I would say it is technology is influencing quietly, but in a real way. Because when it comes to ODR, it makes it genuinely possible for parties in different cities or even in a country. You're sitting in Singapore, I'm sitting in India. We can resolve disputes without ever needing to be in the same room. That cut travel costs, that eliminates scheduling friction across geographies, and that compresses resolution cycle considerably. And I would say the crucial development is the legal recognition, because under the new Act of 2023, online mediation now has a formal statutory place, and that would change everything. It means that online mediation is no longer a workaround or a convenient measure. It is a legitimate, enforceable border dispute resolution in its own right.
Okay, sir. Just give me a minute.
Yes.
Do you see online dispute resolution becoming mainstream in India?
In certain segment, yes, I would say yes. But I'd say it already is becoming that actually. I don't think ODR will replace a physical hearing across every type of dispute. In highly sensitive matters or where digital access remains uneven, physical presence still matters. There's a real limitation we have to be clear-eyed about. But wherever speed, volume, geographic spread are the central challenges, like e-commerce dispute, fintech dispute, platform-based service, ODR is already emerging as a preferred route, not as a backup. So I believe that as digital literacy deepens and legal framework continues to mature, I believe ODR will become the default for a large category of low value but high volume.
Okay, so according to you, what are the skills required to be an effective mediator?
See, this I would say this single most important quality is the ability to listen, and that is something we as lawyers kind of lack, because we listen to argue. We don't listen to we listen to respond. Actually, it is not listening to spot the weakness or a position. It is, we should listen to genuinely understand what is underneath than what is being said as a mediator, because I would say most disputes are never really about the contract clause or the property boundary. They're about the perception, about a communication that broke down somewhere. About, it could be about unspoken fears. It could be about ego that nobody has ever acknowledged. A good mediator hears the legal story and the human story simultaneously and patiently guides the conversation towards options that respect both.
Okay, so the next question is what challenges do lawyers face when transitioning from litigation to mediation practice?
The answer is same as what I said before because the biggest challenge is unlearning. Because we are trained to deliberately argue, to defend our position. We listen to respond. We listen to win. That identity gets rewarded continuously in litigation. But like when it comes to mediation, I don't think it works. The goal is not victory in mediation. No, it is a resolution. So we go from how do I prove I'm right to how do both the sides walk away with something workable. So that is genuinely uncomfortable in the beginning. So that is something that we have to learn. We have to unlearn the process to argue.
Okay, sir. How receptive are clients in India to mediation compared to traditional litigation?
There is hesitation from the client at the outset. There is almost always a hesitation because they think not fighting is equal to giving up or with being pushed into accepting less than they deserve. That fear is real. But I believe that is because they are unaware of the process of mediation. When you sit with them and when you actually explain it, that mediation can save years and significant money, and that they can retain genuine control over the outcome, and that confidentiality exists in mediation, their resistance softens very naturally. So I believe that client's reluctance is almost always about the lack of information, not deep-rooted opposition. So we have to sit down and explain to them what mediation is.
Okay, sir. Coming to policy and future outlook, what impact do recent legal developments or policies have on mediation in India?
The biggest development is recognition because now the Mediation Act of 2023 has come. It has given mediation something that it long lacked, a dedicated statutory identity. Now it covers institutional mediation, court annex mediation, community mediation, online mediation, and it provides a enforcement mechanism for mediated settlement agreement. So that is the biggest development I would say.
Coming to the next question, what changes would you like to see to strengthen ADR frameworks in the country?
Two things. Two things I would say. First is awareness at the entry level among law students, among young lawyers, and among ordinary people who might face a dispute and have no idea that mediation even exists as an option. ADR should be seen as a real accessible first step. It should not be seen something mysterious or something reserved or something that is only sophisticated for the commercial parties. So this awareness is something that we are working. I am working through the mediation society, where we focus on directly and the responses we have seen suggest that the appetite is there when people are given the real information. Second should be the consistent training. High quality mediation requires serious skills. Like there should be deep listening, there should be communication, negotiation. That is something really important. We as lawyers are not trained to negotiate actually. And a 2 day certificate on training does not produce all the skills. No. So we have to invest in rigorous training ecosystem and credible accreditation framework is what I would say.
Okay, sir. Where do you see mediation in India in the next 5 to 10 years?
I see mediation becoming the default starting point for a major and a large category of dispute. Not in the sense that court will disappear, but in the sense that before someone files a suit, they will think, should I talk it out first? So I believe that unnecessary litigation will reduce and the justice system start feeling less hostile and exhausting for ordinary people who currently either drown in the process or give up on it entirely. So it's not like mediation will solve every problem or every dispute. It is never meant to. But as it is a friend or that filters conflict towards right kind of resolution. So that is where I see mediation in the next 5 to 10 years.
Okay, sir. Coming to the last two questions. Can you share a memorable mediation experience that shaped your perspective?
See, I cannot point out a single dramatic moment, but there's a pattern that I have noticed over time. See, the parties, whenever I have sat down as a mediator or as a co-mediator, parties have walked into the mediation. Absolutely certain that dispute is about a legal right. Like it could be about a specific sum of money or a person contract. So that is what they think the dispute is about, and that is what they're prepared to fight over. But as they talk, as the process creates enough safety for things to be said that couldn't be said otherwise, you start hearing something underneath. Things like nobody ever explained this to me. I felt completely disrespected. Nobody cared. So that's a moment as a mediator you realize that this dispute was never purely legal. See, underneath that agreement or that property line or the business falling apart, there's always a communication breakdown or sometimes fear, or it sometimes can be an ego, or sometimes can be a grief that no court order will actually address. So we have to watch out for that. That is a pattern that I have noticed over my experience as a mediator.
Okay, so my last question to you is, what advice would you give to law students interested in ADR?
I would tell them to start early and get as close to the real thing as you possibly can. Join the mediation institution or area societies. The mediation society we are built partially because that kind of structured exposure is what students are missing. Volunteer at the mediation centers if you can get access to. Try to observe the actual session, even as a silent presence in the room. I would say ADR, especially mediation, you cannot understand it by reading about it. You understand it by being in the room. It can be physical or it can be virtual. It should be, but it should be a place where people move from conflict towards resolution. We have to watch it first, right? So by watching what actually work and what doesn't, we learn. And slowly through practice and feedback and reflection, you do it yourself. So the law you can learn very easily. You can by heart the law, but the skills you have to build it through experience. So start building them now and don't wait till you are fully ready because that moment rarely arrives on its own.
Okay, sir, that was a great session. Those who are watching us on YouTube, if you have any doubt, you can comment your questions in the chat box. We will try to take up your questions and we'll try to reply as soon as possible. Thank you, sir. Thank you very much for your time.
Thank you.
We will end the session now.
Sure.